All rise. Court of Appeals, Division 1 is now in session.
Please be seated. Good morning, everyone. We are here for oral argument in case number 1, TX18 Siete Solar versus the Arizona Department of Revenue. I would alert the parties that these proceedings are being recorded, both by audio and video. We ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. We have read the briefs. We've discussed this case this morning in conference. I would alert the parties that we are most interested in the substance of the argument and not the procedure and how the case got here. With that in mind, Mr. Mooney, you may proceed.
Thank you, Your Honor. Good morning. For the record, my name is Paul Mooney. I'm here with Bart Wilhoit. We represent the 4 plaintiffs in this case, Siete Solar, Mesquite Solar, Perrin Ranch Wind Farm, and Arlington Valley Solar. 3 of those are solar, utility-scale solar plants that operate in different parts of the state, and 1 is a wind farm that's located up in Coconino County. They're all properties that are eligible for valuation under the statute that we'll be talking about today. I will try to save 5 minutes of my time, and I'll keep an eye on the clock as best I can to do that. May it please the court and counsel, there's one issue before you today, which is whether the tax court committed reversible error when it ruled that the Arizona Department of Revenue was not required to follow the legislature's timely amendment of ARS 42-14-155 when it set the values of plaintiffs' renewable energy properties for tax year 2015. It is undisputed that the amendment to that statute was effective prior to the date on which those values were set by the department as required by law. It is also clear that the legislature intended that the statute would be in effect on the general effective date because it stated that in its enactment of this particular provision. And it was clear that that date would precede the date on which the values for tax year 2015 would be determined. There is
talking about the assessment date that happens in August?
The assessment date happens on or before August 31st, although they have the right to extend that to the end of November.
Okay. Well, isn't it just fortuitous that this became effective prior to that date?
Absolutely not.
When they passed this bill, they did not know when they were going to go out of session, did they?
Oh, it's been a long-established history in Arizona that the sessions end before the end of April. The law was signed into law April 30th by the governor, and they haven't gone past the end of April in a session for as long as I can remember.
Oh, well, then your memory isn't as good as mine. They typically can go as late as June. I remember when they've had to go in June to pass a budget for the fiscal year.
You're absolutely correct. They could theoretically go later than that. However, this bill was a strike-all amendment that was introduced late in the session. It was a conferenced bill because there were 2 competing bills, one filed by the solar industry, one filed by DOR, that were attempting to resolve a prior dispute that was already then pending. That was the 2014 case that you've heard or read so much about in this case. But that case was already then pending because it had been the subject of an administrative appeal in the fall of 2013, and an appeal had already been filed to court, and the parties were actively litigating it. So the purpose of that strike-all amendment and the conference committee that resulted in the legislation at issue here was to solve that problem.
Well, I don't disagree with you, Mr. Mooney, that it would seem that this bill was particularly was put into place with the intent to address the problem that you've put forward before the court. I guess my question is, they just didn't do it right. It appears that the valuation date is the valuation date for any year as of January 1st of the preceding year.
But that date doesn't conflict with the amendment to the statute. There are numerous statutes in Arizona that deal with the valuation of property every tax year. Since 1994, when we switched the calendar to valuing a year in advance, And by the way, we didn't switch that for centrally assessed properties until 2-3 years later in, I think, 97. But it was originally switched for real property. And one of the obstacles to doing that was there was a recognition that things change and that properties will add value, and the assessors, for example, didn't want to be foreclosed from that. So one of the statutes that was put into place at the time that calendar was adopted, which is the one that says as of January 1 of the year preceding the date of taxation, one of the statutes is 15105, which is what is known as the supplemental assessment roll. That provision allows every year the assessors to set the values early in the year, the valuation year, as of January 1, but also allows them up to September 30th to increase those values in appropriate circumstances. So if there's new construction or something's been demolished or removed, there is a provision in the law that expressly contemplates that because we're valuing property a full year before we're going to ever put it on the tax roll and tax it, there has to be mechanisms in place to make sure that we can still adjust those values.
But this is not omitted property or new construction.
Absolutely not. You're absolutely correct. But it is property that every year is valued by the end of August and has been ever since we went on to this calendar. And it's true of every mine, every utility, every telecommunications company, every airline in the state. All of them are valued under this statute, this scheme, including...
As of January 1st of the valuation year prior to the tax.
That is a mechanical, that is the date by which the value is determined. It's really, think of it almost as an evidentiary requirement, because the tax return that is filed not until April for centrally assessed properties lists all property in place on or before January 1, which is typically the calendar year preceding the date of valuation. So the tax return has to be filed in April, but it's based on information that was known or knowable as of January 1. The as of January 1 has a long history in this state of being sort of a cutoff date, if you will, by which you determine the value. The SMP case that we cited in the briefs is a good example of that, where in effect the court said you have to base the decision to value on what was known or knowable on the valuation date. The valuation date is simply mechanical. There's no dispute about the facts here. The facts are not in dispute. The only issue is whether or not an investment tax credit or a cash grant that was offered in lieu of such a credit constitutes part of the cost of the property of the taxpayer. That was the dispute. Well, wait a minute. You have to report your costs, but you're getting 30% of that cost rebated to you by the federal government. So your cost in the property isn't 100% of what you spent, it's 70% of what you spent. And so if we're going to apply the statute to the cost of the taxpayer, it has to be based on what you actually spent. The clarification, change, whatever you want to call it.
It's not. You've conceded it's not a clarification. It was a change in the law.
I will concede that this court ruled that it was a change in the law. I don't happen to agree with that for a lot of reasons that I articulated in the other case, but I'm not going to re-argue that here. It's now the law of that case.
Okay, so the law was changed in 2014, and there's no indication that they wanted that law. Well, the intent may be there, but there's no indication that they changed it retroactive to January 1st of 2014.
They didn't put a retroactivity clause into the legislation.
Or just an effective date. As in, they could have said it's effective. I mean, there's so many ways they could have told us directly
I don't disagree.
that it's effective on January 1st.
I don't disagree. They certainly could have done it in a different way or a better way, I suppose. But that doesn't mean that their intent was not to change the law.
But we'll assume their intent was to change the law. But if they could have said this applies to tax year 2014, or this applies to tax year 2015, or it applies to retroactively to the valuation date, why would we not expect there to be some language that just tells us it applies to this year?
There are lots of statutes that get passed without a demarcated effective date. It's actually fairly unusual, except in cases where there is an express reservation or an emergency clause with retroactive language.
Where you have a provision that says the valuation date is determined as of January 1st of the valuation year, and the valuation year is the previous year. Wouldn't it have made? Wouldn't everyone in that industry understand how the valuation is done? And so it seems like that would be something that would be part of the legislation. There's no question that it's going to apply going forward. We're now just here based on for 1 year.
But we're not setting the value on that date. We're setting the value as of that date. That is a critical distinction that was not addressed in the prior decision. And the prior decision turned entirely on a statement of issues in paragraph 1 that does not include the question that is being before presented to you, which is the dicta that is in paragraphs 16, 17, and 18 of this decision, none of which was necessary to the resolution of the prior case. The resolution of the prior case turned entirely on the statement this court made in its opinion, or its decision, that when there's an appeal already pending and a law changes and there's not a retroactivity clause, does it apply? And the court said no. The other two changes, by the way, the other two issues that they addressed, whether it was a change or a clarification in the law, isn't really in dispute, as you've pointed out already in this case. And the issue of the old statute isn't before you in this case, because that is indeed how the value was determined. But we submit that the dicta that is in paragraphs 16, 17, and 18 doesn't in any way conflict with the amendment to the statute. I mean, think about this for a second. The legislature passed a statute knowing that it would go into effect before the values would be set, and I do believe they knew that. I do believe they fully understood that. So putting in a retroactivity clause would have been superfluous. There was no need to do it, because here are the parties that are involved in this dispute, both participating in the legislative enactment, and by the way, the Department of Revenue followed part of the new law in setting the value. They took the authorization to develop depreciation guidelines and tables, and they used it to set these values. So they're now picking part of the new law that they were authorized to adopt, and they're applying that to set the values. But they're not applying the rest of it. Why? I mean, is there some indication that the legislature thought this wouldn't go into effect until 2016, 2 years later? Remember, they passed this in April of, well, actually, they passed it in March of 2014. The governor signed it in April. It went into effect July 24th. All of those things happened in 14. But we're not to believe that this is to go into effect until 2 years later? I mean, where's the prospective application language in this statute? There isn't any of that either. The argument can be equally made that there's no indication the legislature intended to defer the effective date of the statute. They said it'll be effective on the effective date.
If we're going under the proposition that the changes in the law are reflected in the next valuation date, I know you disagree with that, but that means when they pass the law in this case, it would become effective for the next valuation date, which would be I mean, it doesn't apply for tax year 2015.
I believe the reason why that's an incorrect interpretation of the law is very simple. It's based on the Constitution of the state of Arizona. The Supreme Court in the Trico case held that Article 9, Section 11 of the Constitution vests the legislature with the exclusive authority to determine the manner, method, and mode of assessing all property. To interpret this statute in the way the department interpreted it in this case abrogates that legislative authority. In effect, it says we get to decide when and how property will be valued, not you. The legislature passed a statute to solve an existing problem. They knew it would go into effect, and they specified it would go into effect on the general effective date. They knew when that was. Let's not kid ourselves. They also knew.
The general effective date is 90 days after they
sine die.
Right.
And they understood that, and they also understood the existing law, which is that the values don't get set until August 31st and can be changed up to November 30th. The values aren't final till the department certifies them to the counties. That date doesn't happen until the end of November. So there's clearly a contemplation and understanding on the part of the legislature that its enactment of a new method of assessing such property, which is its exclusive domain under the Constitution, is not being followed by the Department of Revenue. Why? Why would the department follow part of the new law but not all of it? Why would the department ignore the very clear legislative intent to solve a problem that was then vexing the very parties to this action?
Under 4216-257, the correction statute,
Correct.
it says that the department is to use the valuation and legal classification criteria that were in effect on the valuation date for the tax year.
Correct.
Okay, so let's assume that we agreed with your argument, and now there is another solar company out there. They move to correct for them. Wouldn't the department then look to the valuation, use the valuation and legal classification criteria on the evaluation date, which would be January? So we would have inconsistent results.
No, you wouldn't, because first of all, a change in the law doesn't qualify as a correctable error under the error correction statutes. You read 16251 et sec all the way through, you'll see that a change in the law is not an error. So if the law changes, you cannot invoke the error correction statute. Somebody else couldn't invoke it to go back and try to obtain a similar result. That change in the law simply doesn't qualify as an error. So the deadline to appeal applies to all taxpayers equally. If there was a taxpayer out there that wanted to invoke their right of appeal, they had to file the appeal within the same deadlines that my clients did, which is on or before December 15th of the valuation year. And my clients did that. Nobody else did.
When you say the change of the law, you're talking about a statutory change, or you're talking about a change that was created by a court decision?
No, I'm talking about the amendment to the statute by the legislature, which is what would be implicated by your hypothetical about an error correction. I'll save my remaining time if I may.
All right, thank you. Ms. Newell?
Good morning. May it please the court. My name is Lisa Newville. I'm an Assistant Attorney General, and I represent the Department of Revenue, Maricopa County, and Coconino County. This appeal concerns the Department of Revenue's valuation of renewable energy property for tax years 2015. The department valued the property following the statutes in effect on the valuation date, January 1st, 2014. Taxpayers are asserting that the department must follow a law that did not become effective until after the valuation date on July 24th, 2014.
Mr. Mooney told us a couple of minutes ago that in the valuation at issue that the department actually utilized a portion of the new formula in calculating that. Can you comment on that, please?
Yes, Your Honor. That was raised for the first time in a footnote in the reply brief, so there's nothing in the record. But to be clear, the statute always said the department must apply depreciation. The department always had a formula for doing that. It was required to apply a depreciation schedule. The only change was now the department has published it. But that doesn't change the valuation. If the department publishes what valuation table it always used, that's not a change. So merely publishing it doesn't change the valuation.
There hasn't been a substantive change based on the new legislation?
Correct, Your Honor. The department always used a straight line depreciation based on useful life. That's what the table now says. So there was no change. So we have also...
Change in the law, can you ask for correction based on a change in the law?
No, Your Honor. But your question was correct. If there was a change, an error correction that had nothing to do with a change in law, there was some information that was misreported, you would still have that problem. Somebody who goes through the error correction statute because of some other error would now be applying a different law than those who didn't go through the error correction statute. And that would be a violation of uniformity. You want to have the law the same, which is why, whether it's the error correction statute that specifically goes back to January 1st, the valuation date, or the statute itself, which in this case says valuations for this section must be valued, or the value must be determined as of January 1st. So determined as of January 1st of the valuation year, you're still using the same date. And where the legislature says, hey, we think the valuation date's too early, as with the county assessors and new construction, the legislature knows how to provide an exception, and it did. So the assumption should be everything that there is no statutory provision about has to be valued both under the facts that were known and knowable as of the valuation date and the law that's in effect on the valuation date. And the reason for that is to give everybody a fixed point in time. There are a lot of procedural things that happen after that point. You don't want to be chasing a moving target. You have a set date. You know what the facts are. You know what the law is. Now the parties could work on the valuation.
But why is that different if the legislation had just said this applies to tax year 2014, even though the valuation date was 2013? People didn't know on January 1st of 2013 what it was, but there's nothing that keeps the legislature from saying that, is there?
Correct. The legislature can choose to make a statute retroactive, even though it may upset the procedural process, but that's the legislature's choice. And ARS Section 1-244 states that no statute is retroactive unless expressly declared therein. It is the legislature's choice, and if they want to make that choice, they have to declare that it applies retroactively. And there's been many occasions where the legislature has made that choice, and as you've not mentioned, it has said this is effective January 1st of a particular year, which is the valuation date, and then it's very clear it applies.
Ms. Newell, in looking at this record, I think you're going to agree with me that it's clear the legislature intended this fix to apply immediately.
I can't speak for the legislature. They may have. We don't know. We do know that they didn't say.
Well, the fiscal note attached to the legislation specifically indicated how much money that government was going to miss out on in tax year 2015, which is the tax year we're indicating. So it's clear. It seems clear to me that they intended to have this apply immediately.
Okay.
Did they just not jump through the right hoop?
They didn't have the right language, and I will note that in St. Joseph's Hospital and Medical Center versus Superior Court, that's a case cited in the reply brief, 164 Arizona 454 at 456 to 57. This court says the language of ARS Section 1-244 means language contained in the statute and not inferences drawn from legislative history is what is required. And again, you are drawing inferences from legislative history. Now, if the legislature really meant to apply it to 2015, tax year 2015, it could have gone back the next year and fixed the statute retroactively and chose not to. So we have a situation where it is up to the legislature to do that, and they chose not to originally, and they did not fix it later.
Well, they won't know whether it applied to tax year 2015 until we come out with a decision telling them, right?
Correct, but they do know that this prior court's decision said it's the valuation date. And
in Siete 1.
In Siete 1.
Right.
They said it was the valuation date. There was language in there because there were motions for reconsideration noting that this would apply to 2015 as well. So it's not a complete surprise that this issue would arise. Again, the legislature hasn't tried to fix it at a time where it would have made sense to try to clarify if that's what they really intended.
Is there an impediment to them coming in and fixing it retroactively and offering some sort of credit retroactively to anyone who would have obtained the benefit?
It depends how they do it. Generally, the legislature can do anything as long as it doesn't impact a vested right. And so it would depend how they do it, but presumably there's something they might be able to do. If the legislature thinks it's that important to go back and do something, and again, we have to assume the legislature did what it intended. If you start assuming they meant something else without this language, now we're substituting our decision for that of the legislature, and there does not have to be prospective only language. ARS Section 1-244 is the language that says it is prospectively only unless the legislature says otherwise. So we have a situation where whether the legislature intended and made a mistake or didn't intend it, it doesn't matter. Maybe they changed their mind on the fiscal impact. Who knows? What we have is a statute that could have been made retroactive but wasn't made retroactive. I will also point out that for 3 of these taxpayers, they were involved in the prior case, and we would disagree that it's dicta to say the second part of the holding. So the first part was the 2014 amendment at issue does not apply retroactively because the legislature did not include retroactive provisions. That was at issue in the case. It was decided that it was not retroactive because the legislature didn't have that language. The second part is the Department of Revenue is statutorily mandated to use the valuation method in place on the valuation date unless the legislature specifically provides otherwise. That was actually essential because in that case the court had to decide what are the dates I compare to decide if something's retroactive. And this court said the valuation date is the critical date. I have to compare the effective date to the valuation date. The court didn't say, oh, whether there's an appeal makes a difference. We agree. There is language about this being a case on appeal in the summary part of the decision. It was a memorandum decision. They focused on the merits, the actual substantive part of the decision. And in there is nothing about an appeal pending. That is not a critical date. The critical date, according to this court, was the valuation date. And for 3 of these taxpayers, they litigated what is the critical date, what is the date we have to use for comparison, and they were told by this court in the memorandum decision that the date is the valuation date.
So, and this may be something obvious that I'm just missing, but if a facility is built in August of 2014, the valuation date for the 2015 tax year is?
January 1st, 2014.
But there was nothing there. What value do we put on
The
it?
Department of Revenue must, based on the facts as of January 1st, 2014 for tax year 2015.
So if
So
there's
there's
nothing there,
if it was empty, if it was vacant land, it was vacant land. The county is allowed to consider new construction. That provision applies to county assessors. It does not apply to the state. So there are situations where, because it's a year and a half or 2 years ahead of time, it's not clear who it helps. But the valuation date is the valuation date, unless there's some provision in the statute that says it applies to that earlier valuation date, or the statutes provide relief, such as for county assessors and new construction. For the reasons we've discussed, the tax court was correct in finding that the valuation date, because it occurred prior, this 2014 amendment did not apply, and correct in finding that the 3 taxpayers involved in their earlier litigation were bound by the prior decision and could not relitigate the issue. We ask that this court uphold the tax court decision in full. If there are no further questions.
no,
Thank
thank
you.
you very much. Mr. Mooney, you have approximately 5 minutes remaining.
Thank you. I'll try to keep it focused as I can. One thing I want to correct is a statement that was just made that the Department of Revenue didn't create a new depreciation schedule. They did. That was raised in our complaint. It was raised in the motion for summary judgment below, and it was raised in our briefs. The argument has persistently been made that they followed part of the statute that was amended in the 2014 session as it relates to the depreciation issue. And I might also add that it is not simply a straight line depreciations. In fact, there are 2 related statutes that apply to these facilities, one of which is 4214-156, because 155 by its terms only applies to the equipment. It's renewable energy equipment. If you have land or real property improvements, those are valued under 4214-156. And 156 has entirely different depreciation schedules in the statute itself. So there was a requirement, and DOR insisted as a condition of getting this legislation passed, that there be authority granted to them to adopt depreciation tables. So what was just stated about that's incorrect. The key thing I want to focus on in this brief few minutes that I have is a question that I think is being overlooked here, and it was overlooked by me from my notes, and I apologize for that. The first decision, the Siete 1 decision as you referred to it, did not overrule the case of Waddell versus the Department of Revenue. Waddell was a case that grew out of the Hayden Partners litigation. And Waddell, the court said something very important, which was not overruled in any respect by this court in the Siete 1 case. The court holds that whatever property rights as may exist in a means of measuring a tax belong exclusively to the legislature. The legislature can change the standard for measuring a tax as it sees fit. Can change it any time it wants, up to the date, it says, that the tax is actually paid. Well, let's put that one in context for just a second. Not only were the values not yet set, the taxes were not yet assessed or levied, and that didn't happen until 2015. In fact, the third Monday in August of 2015 is when these taxes were levied. So
that was your argument in Siete 1, that you hadn't paid the taxes, so the legislature could change it.
And it was
Waddell actually, they had a retroactivity clause in Waddell.
But it wasn't used. In other words, the Department of Revenue didn't rely on it. We included all the briefs filed by the Department of Revenue in that case where they said, we're arguing for the then existing law to be applied. That is all they wanted. That is all I want. I want the law that was in effect when the values were set to be applied. Unlike Waddell, the taxpayers had already won their case administratively.
You want the value to apply as of the final assessment date in August, not the initial evaluation date as of January 1st.
That's not a final assessment date. It's not an assessment date at all. It's a valuation date.
The final valuation date in August.
The assessment occurs the next year under the law.
But under that argument, you would have prevailed in Siete.
You're absolutely right. Under that argument, I would have prevailed in Siete 1. But Siete 1 turned on the statement in paragraph 1. When there's already an appeal pending, when the law is amended, if the law isn't retroactive, we're not going to apply it to that case. That's what the case turned on. Anything else the court said is classic dicta. It was not necessary to the disposition of that case. That is the definition of dicta. It's a memorandum decision for a reason, I submit. There was a motion to reconsider, which the department was ordered to respond to, and there was no publication of this decision as an opinion. Denial of review, denial of reconsideration is not precedential. I could cite you the Calvert case and other cases from the Supreme Court that say that. So the fact that review and reconsideration were denied doesn't in any way implicate the validity of the argument that we've made in this case. Simply put, Siete 1 decided the tax year 14 issue in the context of that case, which was a pending appeal. It did not decide it in the context of a case where the values had not even been set. And yes, you're right, it could have been done more artfully. I concede that. I wasn't in the room when that was being discussed. But prior to after Waddell, there was no reason to put a retroactivity clause into this kind of legislation because Waddell held that it was effective anytime up to the date that the tax is paid.
All right. Thank you very much, Mr. Mooney.
Thank you.
The case is deemed submitted. We'll issue a decision in due course. Thank you very much for your argument.